The Center for Democracy and Technology is a nonprofit that focuses on defending online civil liberties, and you're challenging this executive order from the president with a new lawsuit, saying that it violates the First Amendment. What is your argument here?
So what we're most worried about is that this EO is designed to deter social media companies from fighting misinformation, voter suppression, and stoking violence on their services. And what we're most worried about is that it's doing that during an election year. We are very concerned there's a wide public conversation around the power of social media, around the significant volume of conversations that happens on information platforms. And that allows really robust and important speech, but it also allows disinformation and misinformation to spread. We are very anxious about any executive order that is trying to coerce social media companies that are trying to take responsible actions to inform users to flag content which raises those types of concerns.
Now, legal experts say that President Trump lacks the power to do anything about Section 230. I mean, does he really have the power to impact it here?
Yeah, it's true. So the executive order not only raises very significant concerns under the First Amendment, but in addition, it's a runaround Section 230 established law, and really is trying to short circuit conversations on Capitol Hill, as well as in the broader public forum about what could be happening, which is another reason why we're so anxious about the form that it takes.
So the Department of Commerce, the FCC, none of them have taken any action yet, and they still may not. So what is the harm, and what gives you the standing to file a complaint for harm?
So CDT has had a long history of speaking for internet users and the broader public on questions of free speech and content moderation. We've been working on these issues for 25 years. Because retaliation and coercion can have such a chilling effect on injured parties' willingness to bring suit, First Amendment doctrine typically recognizes the value of organizations like ours to be able to speak up in the public interest and fight for these values. Very technically, we also anticipate that under the CO, we would have to expend significant resources pushing back on orders followed by the FCC, on efforts as the FCC or other agencies try to evaluate whether or not companies are in compliance with the executive order. And all of that puts us in a position of material harm that we need to be able to respond to.
Now, Section 230 was written in 1996, before Google existed and when Mark Zuckerberg was still a child. I mean, do you really think that it can remain untouched? Do you expect Congress to step in here?
There's a big public conversation happening around Section 230, around content moderation practices in general. We think that conversation is really important. CDT is at the front lines of those conversations and often spends a lot of time working with companies, pushing back to help think through how do we get better transparency, better accountability in those decision-making processes. So we acknowledge that fight. We do think that Section 230 is tremendously important in terms of supporting freedom of speech. It plays an enormous role in allowing platforms to host and moderate content without fear of lawsuits arising from their decisions. And that really matters. When you start to think about how platforms would react if they are responsible for every single post that goes on there. Thinking about libel for people that allege coercion or violence by police officers, for example. We are very worried about the stifling effect if information platforms don't have that type of protection. I was going to say, at the same time, we do acknowledge that there's a big conversation about how that moderation should happen. We want that debate to take place. What we don't want is the president bigfooting in and deterring companies from taking responsible action to respond to misinformation online.
The case was just filed. What is the actual status of it at this time?
So just filed yesterday in DC court. That means that there's a little bit of time, about 30 days for the government to respond, and we'll be watching for that response.
Twitter is supporting your suit. Have you heard from any other companies, specifically Facebook, about whether they're going to throw their weight or warrant behind this as well?
We got a retweet from the CEO of Twitter. So I suppose that's, that was a nice acknowledgement by them, but we work fully independently. CDT is funded by a wide range of nonprofits as well as by companies, but we make all of our decisions for litigation wholly by ourselves. So this is us speaking up on behalf of the public, trying to weigh in and stopping this type of coercive action on such important questions of misinformation.
Meantime, Twitter has taken a pretty dramatic action in hiding and flagging one of President Trump's tweets. Facebook has taken the opposite position, left the post up, saying they don't want to be the arbiter of truth. Who's right?
So I'm going to say content moderation is really hard. Part of what we want is a freedom and a range of companies and platforms to be able to make individual nuanced decisions based on their own policies and what they think are the right judgment calls. So I'm not going to say what my personal view is of the right outcome there, but what I do want is for companies to be able to listen to what the public is saying, weigh those factors, make nuanced judgment calls on what are really complicated decisions, and have some of that flexibility without fear of the executive branch coming after them for the precise way in which they do it.
Now, you mentioned that we're in an election year, and Twitter is now in a position that they've taken a stand. They're probably going to have to take some more difficult stands leading up to the election. And could that become problematic in itself, in that it's almost drawn more attention to this tweet? And you've got people out there saying this is censorship and perhaps not something a private company should be doing, a slippery slope.
Yeah, so one of the things to note about is the form of content moderation, right? So there's taking stuff down, then there's fact checking it. And for the tweets that are at issue in our lawsuit that we think that prompted the EO that we're responding to, Twitter actually wasn't even taking down that speech by the president. They were just saying, here are the facts on how mail-in ballot voting works. And you may want to read more about this when you see his allegation. So that type of behavior, we really need to think about the role of that type of fact checking. And again, the platforms have protections under the First Amendment. Set aside statutory protections of 230. They have the protection under the First Amendment to be able to make moderation and fact checking decisions like that. I agree that it's complicated knowing exactly how they should do it and serving the role of arbiter. One of the things that we think is really important is making sure that any company making these decisions has accountability in that decision making, is transparent about the type of factors that they weigh, give people a right of redress and conversation as to what is being taken down and why, and that the public can understand what decisions are being made. A lot of the companies have a way to go on that, but we try to work on that and make sure that that's a really important piece of this very, very complicated puzzle.
Now, you just took this job running the CDT 3 weeks ago. You've obviously been a lawyer for many years, but coming in strong, suing the administration after 3 weeks on the job, I mean, can we expect to see more tough actions like this from you? I mean, how does this sort of forecast what's to come?
So this was an issue that we felt we had to engage in. CDT does not file a lot of lawsuits. We have done it for a long time. We were involved in the ACLU v. Reno back 25 years ago. We've fought for free speech for a long time. Litigation isn't our usual tactic, but on a matter of such national importance as this, we just look at what's happening in the world around us this week. The First Amendment and the freedom to speak up without fear of government coercion is more important than ever. And so for me, that judgment just spoke for itself. We needed to speak up and make sure that we took a stand against the executive order.